only talking about whether a president can be prosecuted after he leaves office for actions that he took while he was in office. So,
Right.
Greg, what was the big takeaway from your perspective? There were
Well,
so
I think
many issues.
yeah, I know there was a lot, and I have maybe a more optimistic view about this. I think
Okay,
first,
let's hear it.
well, first, I think these kinds of conversations don't just belong to the court and the lawyers, and I think it's important, and I hope the public kind of notes the remarkable position that the former president is taking in the highest court of the land. That his office, this office that he is running to occupy again, requires him to be able to commit crimes with impunity, to be
That's right.
absolutely immune from prosecution. Meanwhile, he's also arguing, and this came up today in a couple of contexts, that the impeachment clauses must be radically reduced. I don't want to get too much in the weeds of this, but they're a bit self-referring. They argue that you can only prosecute a president if you impeach him, but Trump's lawyers also think that you can't convict on an impeachment if he's out of office. So you could do all the crimes on the last day, or you can do all the crimes and simply resign before an impeachment to protect yourself from prosecution. I mean, it's this. And another point today, they seem to
Oh,
suggest
wait, wait,
that.
wait. Can we just pause on that for one sec?
Yeah.
Because that is just such, it's really emblematic of the strange era in which we live. So, according to the logic of the Trump argument, if the president was just incredibly pissed off at his opponent, he could order his opponent assassinated and then resign immediately after the execution, and he would be completely free and clear and could not be prosecuted for what he had done.
That's absolutely right, and that's the case that the president made. And I mean, I think again, this is. I, I hope that the voting public takes note of this. I mean, the view that a presidential candidate has about the scope of the office and what's required of that office and how judges should treat a misbehaving president and how the Senate should consider impeachments is really relevant to the decision in the election. So that I think it's useful for the country. We had that
Yeah.
conversation and when we heard Trump's position on these things. Um, in terms of how things actually went in the court, I'm a bit encouraged by the fact that that absolute position did seem to have no support on the court. I mean, and you kept hearing. So here's what happened. I think what Trump was asking for, absolute immunity, seemed to me to be dead on arrival.
Yeah.
A lot of the justices wanted to, and this was clear in how they teed up the question. They wanted to examine the implications of this and the hard cases. I'm not sure they needed to do that. I think that maybe it's the best practice for the court to consider the immediate case before them, but they were worried about this. And this is kind of a side point, but I'm not that surprised. I'm the former chief nominations counsel to the Senate Judiciary Committee, and I've worked on the confirmations of several of the justices. Many of them have experience in the executive branch, I think 3 in the White House counsel's office. So a lot of the court, from left to right, comes with maybe some professional experience defending the executive. And then those that come out of the conservative legal movement, I think for largely historic reasons, the conservative legal movement has this bias towards a strong executive in its
Yeah.
DNA. And I could talk more about that later, but you saw some of that from Kavanaugh and Alito, but they kept saying, I don't want to talk about this case. And the suggestion always was, this case is actually maybe pretty easy. I want to talk about these harder cases. And that came out, I think 2 or 3 justices actually said that and tried to move the conversation away from Trump, which was an odd thing. But the court has before it a range of options if they want to do something to protect against the fear of excessive prosecution. I'm not worried about it personally, and I think there's political solutions to the problem if it develops. But if they are so worried, they have outs without letting Trump off the hook, and we'll see what they do. I'm not excellent in predicting final decisions, but there's room there, and I'm not giving up hope that they find a reasonable solution to this case without a reasonable solution that does not unduly limit the ability of the justice system to work against President Trump.
So that's really interesting. So Kim, they did keep saying, I'm not interested in talking about this case. I want to talk about the broader implications, and it's already been quoted many times. I think it was Gorsuch who said, we're going to make these decisions for the ages. And And so they raised a number of hypotheticals, and I'd be curious to hear your reaction. So one of the things they raised is, what about the fact that, Barack Obama ordered the execution of an American citizen living abroad using his war powers, that drone strike? Could George W. Bush, they asked, have been prosecuted for lying about the Iraq War? I mean, I dispute that he actually lied, but whatever. That was the question. Could Biden, by some future president, be prosecuted for some crime regarding failure to secure the U.S. southern border, that kind of thing? What did you make of those arguments, and do you think it's completely frivolous for them to be worried about the implications of worrying about some future irresponsible president or Justice Department that might bring cases because of the precedent that they would be setting with this ruling?
I mean, they're legislating, not only legislating, they're amending the Constitution from the bench as we speak, right? So, judges, as Greg indicated, judges are technically supposed to resolve the balls and strikes involving the particular parties before them. And that's what the DC Circuit did below, only focused on the January 6th case. And they could have certified the question for that case. Is there immunity for Donald Trump if you're taking steps to take an election from the voters through violence and other means, to force Congress to not gavel in the legitimately elected president? That could have been the question, and then it would have been an easy case. But they instead certified the question. I think it surprised people for the Supreme Court in this big issue: what is immunity? When it never existed before. That tends to be what legislators do, right? The legislators come up with a big problem, and they come up with a lot of factors, and they think of hypotheticals, and they understand later judges will fill in the blanks. So in my mind, this is really this is a dangerous game that they're playing in this moment, and trying to establish a test for future presidents and hypotheticals that have not happened. And the better course would be wait for that case. Wait for the case where someone goes after really obvious presidential power, right? And the other mechanisms, the checks and balances, the political pressure, other mechanisms to dismiss the complaint, or all those things. That when there really is an urgency, then you take that case and then you carve out something to protect that kind of core presidential power. The problem with what they're doing is it's creating now. You have to think about it as incentives. What incentives are created by criminal laws? Criminal laws are incentivized to get people to not do things that we don't want them to do, right? It gets people to pump the brakes on something. And so if they're going to lift that for presidents, it is letting Donald Trump or whomever go into the White House the next time and say, whoa, I can get away with even more because the president the Supreme Court has now blessed that. So I also think if those hypotheticals were to have happened, in our 244 or whatever, how many years of history, we might have confronted that, right? So what happened with Nixon was, he resigned sort of impeachment. Gerald Ford pardoned him, presumably with the understanding that he could have been prosecuted. Right?
Yes.
The impeachment clause itself says in the text.
Yes.
Textualists, the impeachment clause itself acknowledges that post-impeachment, you can be prosecuted. So that's in the plain language of the Constitution. So right. I guess my answer, none of this is necessary. And it's going, like this court has been doing, going to create more problems than it solves. It's trying to solve a problem that doesn't exist. The problem that exists is what happened on January 6th, is to try to make sure that doesn't happen again. And that's what Jack Smith is trying to do. And what the court is doing by manufacturing immunity is making that more likely now. It's actually turning that on its head. It's making it, Jack Smith saying, wait, we want to have a brakes on this. We don't want this to happen again, by creating immunity when it's not necessary, and blowing this big bubble up with hypotheticals, legislating, amending the Constitution. They're now making it more likely. They're literally working at odds against what Jack Smith and most of America, I think, in this moment wants to see. And that's why I see this as so dangerous, frankly, and outside the lane of what these justices should be doing.
Well, Justice Jackson had a great point that I think she returned to a couple of times with both advocates, which was on this issue, which was just this. Some of her colleagues are worried that a precedent in this case, allowing Trump to be prosecuted, could open the door to too many prosecutions of future presidents. You know, and she kind of asked, would we be more worried about that kind of precedent or the opposite? A precedent that we set today, saying that presidents are immune from criminal accountability for breaking the law. And I think, you know, just as a conservative, that should appeal to a conservative point of view. Are you more afraid of a government official as powerful as the president of the United States being immune from criminal law or having to answer to too much criminal process? I think that question answers itself, or it should.
Yeah, I thought Jackson was
right, that the
stellar, wasn't she?
Yeah, she was amazing. The justices seem to pick up on that and say, well, we've had attorneys general that are not that, you know, that trustworthy. I mean, they seem to really be more concerned about unethical prosecutors than unethical presidents. And like Justice Jackson, she was knocked it out of the park today. And I think the point is, you know, presidents have powers that no one else on the planet has: the power of the military, the power of the FBI, the power of the CIA, the power of the nuclear codes, the power, you know, all this law enforcement authority, massive national intelligence apparatus that a prosecutor doesn't necessarily have. So it's really that constraining that power that the framers cared about in their No More Kings, the entire Revolutionary War, right? I mean, that's the idea.
So, Greg, let me ask you about the point that the Chief Justice made regarding the opinion below. He seemed unsatisfied with the Court of Appeals logic, because he said, you know, what are the constraints on a prosecutor from bringing irresponsible cases? And he said that the court below basically just said, well, if they bring the case, there's a case. And that was unsatisfying. There has to be some other standard. We know, and a prosecutor, I think somebody even mentioned this cliche, it might have been Kavanaugh, you know, a prosecutor can indict a ham sandwich. So the notion that prosecutors have have constraints, he seemed to be casting shade on that. What did you make anything of that?
No, I mean, some of the things we've been talking about already. I think it was strange, particularly for a textualist court to be so worried about reaching these edge cases that they're not confronted with now. I guess I understand the instinct, but yeah, I mean, it seems unnecessary now. I think that, you know, should we get to a point where we see overzealous and too common prosecutions of, again, former presidents, so we're not dealing with a sitting president, former presidents, there are a range of solutions to that. I mean, for one, I do have more confidence in the system. There's lots of checks there. It's limited to the Justice Department. There are judges involved. There's all sorts of checks. If those fail, and we see that prosecutions are becoming too common and wasting presidents' time, Congress can act too, right? I mean, Congress can create some clarity about what criminal laws apply to the president. It doesn't need to fall to the court to do that. So, you know, we will see. I think the big question is, you know, how academic was this discussion, and how serious are they about, you know, feeling a need to do this? I mean, we can overread questioning, and it may seem that they're going in a certain way, but I don't think we know that for sure yet. And I'm, again, hopeful that they don't aggressively make law in this case that's unnecessary.
So Justice Jackson made a point that I think the appeals court also made in their opinion, which was, you know, actually it serves the interests of our republic very well that presidents do know that they might face criminal liability for being out of control. And you know, what would happen if the president thinks that he has immunity or impunity? That's a scary prospect, because, as you said, the president already has more power than any other figure in our system. So any comment that you want to make about that?
Yeah, and again, we're in this moment because the last president blew through those constraints, the traditional constraints that kept presidents within the bounds of reason and the rule of law and decorum and all those things. We're trying to figure out how do you rein that back in? That's the whole point of these indictments, because the other things failed, right? Congressional oversight failed. Limits on appropriations failed. That was the first impeachment. The 25th Amendment was floated, but no one was, it doesn't actually apply. No one was willing to do it. Impeachments failed. Like all the other guardrails for Trump didn't work. And so, I mean, I wrote a piece for Politico a couple of years ago that kind of made this argument because I had done this thought experiment with my students. We went through all of the guardrails and pretty much everything except for a criminal indictment, Donald Trump had blown through. And what the analogy I like to use, which really resonates with non-lawyers, is a speed limit. If the Constitution's a speed limit and you're seeing 55 miles an hour or 35 in your neighborhood, and you can blow through it 10 miles over, you'll never get a ticket. And then one day you do it and you get that horrible thing in the mail for $125 that has a picture of your license plate. Everyone will slow down. You'll slow down.
I have never experienced that. What are you talking about?
Especially in Washington. But the point is that it's not the speed limit that makes you slow down. It's the consequences for violating it that make you slow down. It's the accountability that makes that speed limit mean something. So if the Constitution is designed to make sure no more kings, no one has unlimited power, that threat, as you indicate, of criminal prosecution is the ticket for speeding. And the justices kept saying, or I wasn't the justice, it was actually counsel for Trump saying there's other guardrails, but really none of them worked with Donald Trump. They certainly didn't stop January 6th, right? It was Mike Pence who said, no, I'm not going to do it. It was people within his cabinet, right, who said, that's a bridge too far. I'm not going to do that. And that's not a check and balance. That's just having integrity. And the whole idea was the framers understood you can't just make sure, just like when you hire someone to work in your sandwich shop, you can't be sure everyone's not going to steal from the cash register. You have to have checks and balances. It's the same concept. And that didn't make it into the argument, Mona. And frankly, I thought the government could have pushed that a little better. They didn't. It seems like and I know Gregg knows this, but when you start making concessions and answering hypotheticals the way a justice is asking you, clearly wanting to make a point, he was doing that. I mean, they were on a roll with him, the conservatives. I think he lost some ground, frankly, that maybe just Preligar, the Solicitor General, might not have done.
Interesting. So one of the points that, so Amy Coney Barrett also had a nice day, I thought. And she asked, how could it be that they were arguing? So she pointed out one of the logical contradictions, which was the president's lawyers were arguing that he should be completely immune from consequences for illegal acts unless he is first impeached and convicted, but that he should also be prosecutable after impeachment. So is it he's completely immune or only after impeachment and conviction? And what about the case that we were discussing earlier when he can evade impeachment? It was
last point, and then I do have to hop off on that.
Okay.
But
no, it's okay.
Remember Mitch McConnell, right? Remember Mitch McConnell on the Senate floor, who said basic or temporal, the timing of the impeachment, the fact that the trial happened after he was no longer president, he made kind of a very technical reason why they were not going to convict him for January 6th under the impeachment clause. But he said the justice system will take care of it. So, even Mitch McConnell in the moment assumed, and he used that as an excuse for not doing that impeachment. So again, or not convicting, to your point, what's left? Where's the ticket for speeding? It's not impeachment. It's not, it's not indictment. What is it? And that I hope, I agree with or I said, I appreciate Gregg's optimism, and I do hope that makes it into the majority opinion.
Yeah.
I didn't hear a lot of it today, but anyway, I've got to run. But
Well, thanks so much for joining
Yeah.
us, Kim. We
Yeah,
really
it's a great
appreciate
conversation.
it.
Take care, everybody.
Okay. All right.
Thank you.
So Gregg, a few more points here. I took some notes. So so one of the arguments is let's see that so Sauer argued, these other checks and balances, which of course have not worked. And he put a lot of emphasis on that. He also made the case that if a president does not have this absolute immunity that they are arguing for, that he cannot do the kind of bold, imaginative leadership that we want from a president. I was kind of gobsmacked by the fact that he said that. I mean, I know it was in their brief and everything, not those words, but I mean, isn't it an amazing argument to make that a president has to be able to go out there and break the law if he's going to be an effective chief executive?
No, it is absolutely amazing. And as I said, I mean, there are other ways, if you're worried about too much criminal exposure, there are other ways to address this problem. But yeah, it's stunning. And he's trying to speak to this real idea at the founding and the Constitutional Convention and the Federalist Papers that we want to have a vigorous executive, and we want to have an executive who can be powerful. And this was after several years of Articles of Confederation where we had a weak executive. So the framers certainly wanted a president that could act and would not be too tied up by Congress. But that I don't think they wanted a president who was above the law, and they were very clear about that. Justice Kagan pointed out today, I think it was Justice Kagan, that the founders were aware of a concept of immunity. There's limited immunity for congressmen for speech and debates. There were immunity options, immunity provisions for governors in some state constitutions, and they chose not to adopt an immunity standard for the president, and it's served us pretty well. But yeah, there's a lot of convenient legal arguments that are made by Trump defenders all the time to kind of avoid the immediate consequence and move on to the next thing. And if you put them all together, it's an argument for complete lawlessness and an unfettered and unchecked executive. It's become another hypocrisy. Go ahead.
Oh, well, I was struck by that reference also to the fact that the founders knew about putting in immunity. There was some governors in some states had immunity. Yep. And they chose not to put it into the Constitution. And it was interesting that observation came from the more liberal justices, but you would think that the conservative textualists would be very alive to this kind of history and would take that very seriously. None of them commented on it. I guess we can't judge anything by that, but what did that strike you as something that, when they're actually in chambers and thinking this through, that they will take seriously, or no, none of the conservatives noted that?
I think that, look, a lot of doctrine around presidential authority is developed by the court, and it's kind of based on this just notion that we have an executive, and the executive has these core powers, and we cannot allow things that would impede on that power. To me, there's no real danger that criminal liability would impede on the ability of the executive to function. I think clearly in this case, again, the question about whether they need to go beyond the facts of this case, certainly a president unlawfully attempting to stay in office and prevent his successor from occupying the office lawfully cannot be a function that we want a president to feel free to perform. I mean, this is not part of being the president. I mean, there's such as this core irony at the start of the case. I think Justice Thomas asked to the attorney for Trump, where do you find this immunity? And he said, well, it's in the executive vesting clause of the Constitution. It's just this idea that we have a president who has executive power. Now, of course, the executive vesting clause of the Constitution is exactly what Trump was trying to undermine and prevent by preventing the vesting of the lawful power of the
That's a
executive
good
in
point.
Biden. So
Yes.
it's circular. It can't be.
Right. Now, they spent a lot of time today going over this distinction between official acts and private acts. And the argument being that if it's an official act, that it perhaps be covered by some sort of immunity, but if it's a private act, it wouldn't. What do you make of the fact that the former president's attorney conceded that a number of the acts that are listed in the indictment were private? You know,
I'm surprised by that, but it is a way to resolve the case in a number of ways. I mean, one, you could
okay, let's
say,
hear it.
well, one, you could simply say that everything alleged here is private because this was not about the lawful function of the president. This was about candidate Trump trying to prevail or steal the election. And this is not, and in fact, the founders were very careful to keep the president out of the election because they've got a motive for self-dealing. There's no presidential powers related to administering an election or certifying the next president. The vice president's got the ceremonial role, but not the president. So I think it's very easy to say these are all private acts. Even if there might be some immunity for official acts, they're not implicated in this case. We don't even need to talk about it or settle it now. We'll just mention in dicta that they might be limits out there on official acts. We'll cross that bridge when we come to it. And that would be, by my lights, a great resolution to this matter. Less great, but there is sort of an in-between path, which you've mentioned. Perhaps they do say, well, there's a mix here. The court's below need to figure out what was official and what was private. And I think the attorney for the government was asked, could you bring this case on after you pull out some official acts? And he said, maybe. You have to look at it. So the question is how they frame it, what the test is, how long it would take to process that. All those things matter about how great a result that is, or how.
I'm sorry to interrupt, but I just have a question. Can they determine that themselves, or do they have to remand it and say the trial court has to decide that? Could the Supreme Court itself just say none of this was official? It was all private acts?
Yeah, I think so. I mean, I think it depends on how you frame it, but generally the Supreme Court's the last word on matters of law, and the lower court needs to do fact finding on matters of fact and apply the law to the facts. I think the court could conclude that as a matter of law, this type of behavior is just categorically not possibly official acts, and therefore there's no fact finding, there's no analysis to conduct by the lower courts, and they could do that.
What do you think will happen?
Oh gosh, oh no. I've made bad predictions for the last 10 years, so I don't know. But I think I'm hopeful that there will be a result that will allow the process to move forward against former President Trump. The timeline we're on now, it does not look likely at all that it results in some sort of conviction or final verdict before the election. But I'm hopeful that the court will have some language that underlines the seriousness of these matters, legitimizes the process going forward, and perhaps allows some fact-finding or process in the trial court before the election.
So, but the
I've been too
timing
hopeful
here,
before.
we have all been, that's join the crowd, but the timing is such, I mean, tell me what you think about this. When I heard that the court, after what seemed like a long delay, weeks-long delay after the appeals court decision, had accepted cert, I thought, well, that's game over, because by the time they hear oral arguments and then issue a ruling, we're going to be out of time, and then possibly remand for further findings. Then we're going to be out of time for a trial realistically. Was that wrong? What do you think?
No, I have mixed feelings on this question because, look, I mean, I think it's certainly in the public's interest to have some resolution before the election. I think that undue delay is something the courts and the Supreme Court should be blamed for and scolded for. But also haste to move ahead a criminal process is not within our tradition. We talk about the right to a speedy trial. That's a right for the defendant, not for the public and the prosecution. So I don't know. The court's moving. Things have moved more slowly than I would like, but not as slowly as they could. There was sort of for the court has a slow process, but for the court, this was a pretty quick turnaround from taking the case and scheduling argument. And I'm hopeful that they will be prompt in a resolution of this matter in the next few weeks. So it's I think there are countervailing concerns, but my original hope, and I think this still would have been the better course, would have been that the court had not taken this at all and allowed the DC Circuit's ruling to stand, because I think the court could have waited for a more challenging case and a closer call to take up this if they're really worried about kind of the core presidential powers and their potential to be chilled by unlawful or overeager prosecution.
Okay, one more thing, and then we can wrap this up. But I was struck by something you said about Justices Kavanaugh, Gorsuch, and others, where you said, that there is this bias in conservative jurisprudence that believes in a very strong executive, and there's a concept called the unitary executive, and they spend a lot of time on trying to argue that there should be great deference and scope to executive authority. And I used to believe in that before history showed me the dangers of energy in the executive and too much authority in the executive. And I'm just wondering whether you think there's been any rethinking of that on the part of conservative legal types in our time.
Yeah, it's gradual, and I think that, again, I think I mentioned before, I think some of it's an accident of history. The legal conservative movement, the modern one that we know, really came together in the aftermath of Nixon and Watergate, and there was a feeling that the Democrats were overreacting, and this huge Democratic majority in Congress was really unduly burdening the executive. And this was, again, an era post-world United States was Democrats controlled Congress and Republicans often controlled the White House. So there was also this kind of idea that the left was on the other side. So I think this really shaped the way a lot of Republican lawyers and conservative lawyers think about executive power. I think it's maybe changing a bit in some contexts. I mean, one, certainly in rulemaking, there's this Chevron case, which is controversial now on the right. There used to be, and it was once championed by conservatives, this idea that the courts should defer to executive regulatory agencies in how they interpret the statutes and the rules they issue. And that's changed. So it's at least changed with respect to the administrative state. It seems to have changed less with the president himself and the office of the executive itself. But I hope there's more conversation there. And I think there's kind of two categories of questions. There's the unitary executive, which is really about what does the president control? Does he control the executive branch, or are there agencies and sub-agencies that are independent? And I think conservatives are fairly uniform on the idea that there is a unitary executive. The Constitution says executive power is vested in the president. Everybody else works for him and derives their power from him. But the second question, so that's what does he control? And then how much power lays there, I think, is a completely different question. How much power does the president have with respect to the other branches, to Congress, is a different question. And I think that's open to more debate. I'm hearing a little bit more of it, particularly with academics kind of who are conservative and libertarian. I hope that conversation broadens. And it's one of the things that in our organization, the Society of Rule of Law, I'd like us to help foster debate about that. I think the conservative legal movement, for a variety of reasons, has focused kind of almost exclusively on the role of the courts for a couple of generations. And I think we need to have a much deeper conversation about the proper role of Congress and of the executive.
Well, thank you so much. That's a good spot on which to end things. And really appreciate you joining us this evening. And thanks to all of our viewers and listeners. And